Maria penmi ka High Court ia karai baga jingthung ia ki Parliamentary Secretaries kalong ka babian mentagas ni ki MLA ki basha thung kum ki Parliamentary Secretary kila resign no baro abakren bat kilat pathai khobor Menteri Rangba ka jenla Dr. Mukur Sangma ulai thu bawlayo pediang ia ka sithi ia no kam jang baro ki MLA ki babat ia ki kam Parliamentary Secretary hadien baga kashari Meghalaya High Court kala penmi ia ka ni karai Ulang banagaliang sarkar kan sebisar bahaya kini gerai syab kania syakmat kumno banle namar baya ke jingtung ya ki Parliamentary Secretaries latung kat kum melatau dak sarkar jelah lingba ka artikel sispak dai puai kriti sensar kari ka ba ailat ya sarkar bakan tau an ki kidan kumba khat sanmut ki MLA ki babatru ya kam Parliamentary Secretaries ha sarkar MUA tu ka balai alam dak Kongres hagoi pat kaliang Menteri Rangba ulakan pai man penhiar syuki ya kong amprin lingdo wat hadian buka High Court kelapan mi ya hukum kebak pendam ya jingtung kam nong ikai haki skol sarkar kebak kong amprin kedai kawai ni menteri kebasyak kedokti stop tu takhamduna la
in two different cases. One is the ruling of the Honorable High Court pertaining to the issue of the education scam. And another one is pertaining to the issue of parliamentary secretaries and the constitutional validity thereof. Now, what I have been informed is that today we are getting the certified copy of the ruling in as far as the parliamentary secretaries are concerned. Based on earlier ruling of the Honorable Supreme Court, they have set aside, as I am informed, the Act itself. Okay. So, now, appointment of parliamentary secretaries are based on this Act. And this Act is again based on the constitutional provision at Article 91, I think, 191 or that relevant provision of article which allows the state legislature to make laws. Wherein by that law, the members of the Legislative Assembly will be prevented from getting disqualified for holding an office of profit. Okay. So this particular law has been enacted based on this mandate of the provision of the Constitution, because this power to enact such law by which we can prevent the members of the August House from getting disqualified for holding an office of profit, wherein the law will say such office will be deemed as not as the office of profit. Okay, that's the law which can be made by the state legislature. So, since this provision is there, therefore this particular provision also was included in the Principal Act. Okay. Now, therefore, based on this ruling, which is again based on number of similar rulings by the Honorable Apex Court, we will examine it, and then before we decide on the further course of action by the government, the parliamentary secretaries have already met me. They have decided to, since the law, the Act itself has been struck down, or rather set aside, therefore, irrespective of what the government decide, all my friends holding the post of parliamentary secretaries have collectively decided to submit their resignation, which I have accepted. Okay? All of them.
When was this?
Collectively, today they have met, some delegations have met. In fact, they were meeting me and discussing on this issue for in the preceding weeks also, but I said wait for the ruling of the Honorable Court. So this is the status. Okay. Now it's an issue of whether the government will actually look at further to see whether these provisions should still be provided to the government, because we have to look at from the perspective of the provision of the Constitution, whether the constitutional provision in that relevant article of the Constitution which provides the state legislature and also for Parliament, as the different articles are there, to make such laws can be properly deliberated upon before the Honorable Court, and therefore enable such law to operate in future. That we will examine. Is the law which we are talking about. It is only because of this law that you are appointing parliamentary secretary. If this law is not there, then you will not appoint. Number one. And number two is that this law was also made because of the provision in the Constitution. Okay. the provision of the Constitution which says the state legislature can make such law which can prevent the member of the House from getting disqualified for holding an office, and which shall be through this enactment of law deemed as not as an office of profit. Based on that, like you have chairman, you have co-chairman, all these things are that's how you had that particular serial number of members of district council. That was also in that principal act. That's why we have to look at the operational part of the ruling of the Honorable High Court, based on which we will be able to tell what should be the further course of action. Because it's the act which we are talking about, and because the act is there, that's why the appointment is there. If act is not there, then you don't appoint. The ruling is concerned, because this ruling also has lots of ramification, and that ramification has to be examined from both legal perspective and constitutional perspective, and from the principle of natural justice perspective, since it affects all categories of teachers who were appointed after the whole recruitment process. Therefore, the government is examining from all this angle, and based on which further course of action will be decided upon.
Any plan to drop the concerned minister from the cabinet?
I know you will come only to that. Now you see, issue of dropping or not dropping of a minister is also again linked with the outcome of the case, in particular with the issue of any alleged involvement of the minister concerned. Now we have waited for the outcome of the ruling of the Honorable High Court. This case has not only been confined to the Honorable High Court, it has gone up to the Honorable Supreme Court as well, and then it has been there for quite some time. And we have decided to wait, okay, let us see what is the outcome. Allegation and the ultimate finding of the whole investigation and pronouncement of judgment should be the guiding principle for my government, and that is what stand I have taken from the day one. There are many such cases, not just this case. Okay, so we have taken a conscious stand that allegations, and based on those allegations, the whole process of law and the outcome thereof will be taken as the guiding principle for us to decide on the outcome of fate of any member of the cabinet. To put, because we are talking about an issue which pertains to the ruling from the judiciary. Okay, we don't talk in detail. We are not here like this media channel where sometimes you can generate open discussion and debate on these things. I am not really comfortable to discuss and debate on those things.